Welcome back to another episode of the Auto Accident Attorneys Podcast. I'm your host, Attorney Ali. Today, I am joined by one of my favorite guests and in-house podcast counsel specialist. I was trying to come up with something off the riff. Attorney Rishi Patni of Patni Law Group. Welcome back, Rishi.
Thanks so much for having me. It's a pleasure as always.
I hope that it wasn't too long of a commute to get here.
No. I mean, the 15 steps down the hall was, it was manageable, but every now and then there's a little bit of traffic along the way. It was pretty good today.
Jetty gets you caught up every now and again.
That's usually the worst of it. Yeah. Jetty does seem to cause a little bit of traffic backup.
Actually, Jetty's in here. Well, she's laying down on the ground, so she won't be on camera today. But I do appreciate you taking the time to step in and record with me. We always try and put content out that is in line with our motto, we take care of you. Yeah. And so we were riffing on your commute in today on what information can we provide listeners today that would take care of them and maybe things that they don't typically think about. And you had mentioned, what if we discuss wrongful death claims?
Yeah, it's something. It happens in traffic accidents, and so you get phone calls about it, but it's a little bit different because it's not your typical the person that was injured in the accident that's calling you. Unfortunately, that person is no longer with us, so you're getting calls from a family member, and there's some nuanced differences with those type of claims, and so I thought it'd be good for your listeners to understand how those claims are similar to other traffic accidents and auto accidents that you normally get calls from, where it's the injured party that's calling you, and also how they're different, and in the fact that a wrongful death claim has multiple different components.
I think the best place to start is at the beginning when we get that intake call, right? And let's just say it's a surviving, let's make it interesting. It's a surviving spouse.
Okay.
But the spouse doesn't speak English. So it's the child of the surviving spouse
That calls
in.
Absolutely. It's something that I think we see quite often. But it's so what normally happens in that case? Well, the family is typically still your client, right? So when you talk about who you're referring to, and I do it until I understand exactly who is going to be the named representative, I refer to the whole family in my letter of representation because you're not sure exactly who's going to have what claim, and it's something that you want to get out to the at-fault party, if it's a motor carrier, to the trucking company, and obviously to the insurance company, a letter of representation. So those are they often go out before you have all of the nuanced details or some of those decisions have been made. So when I refer to who we're representing, it's the whole family, but it is in regards to the death of a specific person that results from an accident.
So you're mentioned the letter of representation. That's the first correspondence to typically the insurance company of the at-fault. In this situation, we're talking about auto accidents, at-fault driver's insurance company. So it establishes that the first line of communication with that insurance company saying, hey, we represent this family.
Right.
Prior to the letter of representation going out, who is signing on the line that is dotted?
In that case, you would have anyone that has the capacity to retain counsel. So, in your case, if there is a surviving spouse that doesn't speak English, but is able to understand, and the child can communicate and translate, I would want the surviving spouse to be the person that signs on the dotted line. But if communication is an issue and that if they wouldn't serve in a representative capacity, then you can have the surviving child if they're going to be the ones to carry forward. There's some limited exceptions where in a wrongful death circumstance, when you have a surviving spouse, they're the ones that are typically given the wrongful death claim, or that they're going to bring it forward. But but you could have some unique circumstances or under limited circumstances where, even though there is a surviving spouse, a surviving child can bring the claim instead of the surviving spouse. But one thing to remember, and something that families want to know kind of, very early on, is what happens to any proceeds from this accident. And so, it's very specific. The surviving spouse shares with all of the surviving children, but the surviving spouse can't get less than a third of any recovery of a wrongful death claim. And so, the children can take, they can split it equally so long as there's only two children. If there's more than two children, they're all going to share 2/3%, or 2/3 of the recovery, and 1/3 would go to the surviving spouse.
That I actually didn't know. So the surviving spouse does not receive the entirety of the settlement funds.
Correct.
It's 1/3 surviving spouse, 2/3
Well,
the issue.
It's split equally between the surviving spouse and the children, so long as the surviving spouse doesn't get less than a third. So the surviving spouse has to get at least 1/3 of the recovery. So if there's 3 or 4 children, that would dilute the surviving spouse's recovery. If you have a surviving spouse and 2 children, it's 1/3 each.
Right.
But if it is just if it's a surviving spouse and 1 child, the surviving spouse would get, they would get half, and the child would get half. So, but the surviving spouse cannot receive less than a third.
And in what circumstance would surviving spouse take the entirety of the settlement?
If there's no children.
And is this regardless of any will? This is the default rule. So if somebody passes and they don't have, what do they call it? A testamentary document?
This goes back to property law, but I believe the term is if they die intestate.
Intestate.
If they die without a will,
Right.
Then it follows. But when it comes to, because these are what they call survival claims, so your claim survives your death. These are statutorily developed in a way so that regardless of whatever is in your will, however you've bequeathed all of your assets and provided for, the wrongful death claims and the proceeds from a wrongful death claim supersede even the way that you would have your will set up. So you can write, a child that you don't like out of your will, but they would still have a share of the proceeds of a wrongful death claim that's brought on your behalf.
That's an interesting piece of information that I don't think many listeners would ever consider ahead of time. So in our example where we have, and I'm probably bearing the lead with you at least, since we've already discussed these particular facts, but in this completely hypothetical example where we have a non-English speaking surviving spouse, and she has 6 daughters, and she receives we settle the case. She received the settlement. She's the one that has retained the firm. When the settlement comes in, let's walk through the logistics of that distribution of settlement funds with the matriarch, the surviving matriarch of the family, and the 6 sisters. And then let's throw in the wrinkle of conflict amongst the sisters.
So in that case, this is where representation of the whole family becomes really problematic, right? Because of the conflict, and it is this is where it is best to get a probate attorney to look it over, because they will always be able to tell you exactly how to do it in a way where you're not making the call yourself. When it comes to those more complex things, I tend to refer out to someone that handles probate and family law. But I think when it comes to just the wrongful death claim itself, now remember, when there's a wrongful death, when a person dies as a result of the negligence of a third party, there's two types of claims. There is the estate claim, which is and that is held by the benefit or the administrator of the estate, whoever's appointed, and that is separate from the wrongful death claim. Now, the estate claim is all of the special damages that are, all of the medical bills if the person survived and received medical treatment for a period of time after the accident, the funeral burial bills, and all of those expenses, and then also if there is an element of pre-accident fright and shock, those also belong to the estate. So if there's a period of time where before the person died, they knew that their death was imminent, and there's an element of that mental anguish of knowing that you're gonna die, but and you're conscious of it and you are in pain. There, the classic example of that is somebody that is, after a horrific accident that involves a fire, and and you've got a family member that is consciously in pain being burned, and you'd obviously have to show that there was conscious pain and suffering for a period of time, which is typically, um, it's tough to hear for most jurors, but somebody describing the pain of a family member burning, it's something that it's really, really, it's tough testimony to talk about, but it's incredibly necessary because there's a huge element of the damages that are recovered in that case, which deal with pre-death fright and shock, and the conscious pain and suffering prior to death.
Now, why you're talking about the claims that are owned by particular entities? Why are those claims owned by the estate of the decedent, the person that has passed?
So those are claims that are because those are legal claims that are essentially repaying a lot of the a lot of the special damages. If the people who from where those claims or those expenses were incurred, they would seek repayment of those. For example, the hospital that treated the patient prior to dying, the ambulance that transported the patient from the accident scene to the hospital, when they seek repayment of those, the estate is the legal entity for somebody that is no longer alive, from where you would seek that payment. It is the legal fiction entity that is created to handle your affairs after your death.
Now, on today's episode, we have very clearly one empty seat. So this is indicative of a volume 2 for this episode.
Where we can bring it, exactly.
We're going to bring in a probate attorney to discuss this, but let's plant some seeds. This is the ultimate cliffhanger for our listeners. And you know this because I say it every time. The person who's most interested is going to be my mom. So my mom is tuning in for episode 2 of this. And we're talking about the estate, that legal fiction. Is that what you just said?
Yeah.
The legal fiction of the estate being, it owns those rights.
I mean, we treat it as if it's an entity, but it's kind of like an LLC, right? An LLC is nothing but a legal designation by the Secretary of State that gives life to something that is just it's a name, right? So the estate of some person is just the legal designation given to the but the estate does have assets, and there's what they call the corpus of the estate, which is all of the property that the person that died intestate holds. And even if they die with a will, they can still designate someone to be the administrator of the estate, and then they would also be the designation of that entity. They're in charge of that entity, marshaling all of those assets together, and then being responsible for paying out the claims as necessary. And these are claims of people that are owed money from the estate. So the same way that if I were to die in an accident, but I were to I'm sure American Express wants to get their final check on the last credit card statement, so they would recoup that payment from my estate. And so all the people that I would owe money to, they would get that money from my estate.
So you already dropped some hints by comparing it to an LLC, but I liked that you had said it was like a legal fiction, because it was presenting the opportunity for me to say, well, so does it actually get set up? Is it automatically set up? So let's get into the logistics after death. Is an estate automatically created as a legal fiction, or is it something that has to be proactively created and it actually exists.
It has to be done proactively. There have to be affirmative steps that are taken, petitions filed with the court to create the entity, and then to also appoint someone to be the administrator of that entity. That administrator has the role of a fiduciary, which is that they can't be personally interested in it themselves. They can have an interest in in the proceeds of the estate, but they have to act in the best interest of all of those, both creditors and beneficiaries of the estate.
So since we're talking on estates, I want to come back again to our theoretical example of the sisters, but that I was walking down a pre-litigation example on that. But since we're on estates, let's go through let's say this auto accident occurs. There is $1 million of insurance available. When the law firm or the attorneys try to settle this case, they cannot get the full value of the entire insurance policy. So litigation starts. We file suit. In order to file suit, the first thing that needs to be done, you were mentioning, the entity has to be created.
Right. So you want to have the estate set up. When you file a wrongful death lawsuit, you're filing both the wrongful death claim, which we talked about, belongs to the surviving spouse, but it can also be brought by the surviving children. But typically, the easiest way to do it, because there's only a few very narrow circumstances where, even though there is a surviving spouse, the children will be allowed to bring the case. And that is where, if there's a level of incapacitation or a refusal to bring the case, that the children can petition the court to be allowed to bring the case, the wrongful death case. But if there is a surviving spouse, it's brought by the surviving spouse, but the proceeds have to be shared with surviving children. And then that's the wrongful death part of it. Then the administrator of the estate is the one who brings the estate claim, which is your all of your medical bills, special damages, post-accident expenses that were incurred, and then pre-death fright and shock and conscious pain and suffering.
So on court documents, when there's a lawsuit filed, we're just going to use the name John Doe v. David John.
Right.
What is the plaintiff name?
So there you would have so-and-so, the surviving spouse. So let's say Jane Doe as the administrator, as the administratrix of the estate of John Doe. And then if Jane Doe is the surviving spouse, so she would be bringing it in her capacity as the administratrix and also as the surviving spouse. Now, let's say you've got the probate court appoints somebody else other than the surviving spouse as the administrator of the estate. Well, then you'll have, John Paul as the name of the administrator of the estate. So they will handle the estate claim. And then you will have Jane Doe as the surviving spouse bringing the wrongful death claim.
What happens if the administrator of the estate wants to settle the case, but the surviving spouse and children think that the value isn't high enough?
That is interesting. When you have both of those components, I think that's where you would want it can get dicey, because you could actually have arguably the estate claim could be resolved separately from the wrongful death claim. Though they are two different elements of damages, and arguably they could. I think it would be very rare and probably be a little messy to parse those out. And this is where joint representation of the administrator of the estate, as well as the surviving spouse and children, or the beneficiaries of the wrongful death claim, can actually, I could see it developing into a conflict if it can't be resolved through just a frank discussion. But to the point where there actually is a conflict, and your parties, your jointly represented clients have different interests and different goals. That's where a conflict may prevent you from pursuing the case jointly, or jointly representing all of them.
Okay, so this is where the empty seat number 3 will come in handy for episode 2.
Absolutely.
So,
This is where I'm starting to wade into those waters that that I would typically rely on a probate attorney to say to guide me along the way for sure.
so what are some other considerations? Let's go back into pre-litigation. Some considerations that people may not think about. Where, by the way, I probably should have said trigger warning in the beginning of the episode. I hope that the nonchalance that we're speaking about these topics is not a trigger for anybody, that nobody's feelings are hurt
Yeah,
here.
I guess we tended to be a little bit more cavalier when we talk. I mean, obviously, we're not, we're certainly aware that these accidents are tragic accidents.
Right.
There are, really emotional times for families, and they don't come to us, with the same cavalier attitude that we can discuss them with. But I think, we're able to talk about them a little bit more objectively and what may feel cavalierly because we see so many of them, and it is fairly commonplace. It doesn't mean that we've lost the ability to appreciate how tragic it is and how significant it is for any family to go through this. But there is a level of objectivity that's kind of required where you talk about how to handle these types of cases.
And it's something that you want. And I'm not saying that from sitting in the position of an attorney, even if and when it happens in my own life, when I go and I seek counsel, I appreciate empathy, but I want counsel to have a level head. I want counsel to be objective. I want counsel to know exactly what needs to be done. And that's sort of the purpose of the conversation today, so that there's a little bit of insight. One of the worst things is when people, especially in a time of tragedy, when people are faced with things that they had never considered before that would be, what was it, Donald Rumsfeld? There's things that we don't know that we don't know.
And things that we do know that we don't know, and what's dangerous is the stuff you don't know, what you don't know about what you don't know, which is
Right.
most dangerous, right?
Which is the worst time to find out, to know about something that you didn't know about, is in a time of tragedy. So hopefully this conversation has people at least exposed at a high level to the concepts that could come up, so that they, at a minimum, they know that they don't know about these things.
Right.
So that when it comes up, it's like, oh, okay, well, these are things that we need to learn about and take into consideration, get appropriate counsel for.
I think estate lawyers also preach the same thing, is that these are necessary conversations that are very helpful to have when you're able to do it with a level head, when you're a little removed from the emotions
Right.
of these events coming to fruition. So yes, it's morbid for people, and people don't like, it's not a comfortable thing to think about. Well, how do I plan for what's going to happen to my assets, my property, my children, my things, and my relationships after my death? People, it's a very uncomfortable thing to think about just arbitrarily, but it's a very necessary thing. That if you want things to happen a certain way, you have to give some thought to that during your lifetime and plan for it.
Yeah.
And so it may be uncomfortable, but it's certainly a very helpful and necessary conversation and thought process to go through prior to that.
I 100% agree. And I'm actually already looking forward. We don't even have the guest lined up, but when that guest sits in that seat, I'm excited for that conversation.
Absolutely.
So going back to pre-litigation, I wanted to get that disclosure out, that I hope that nobody is upset by the nonchalance and us being cavalier about the topic, which I don't think we are. We're just not, no one's died right now.
Correct.
Right? We're not dealing with the
We
tragedy.
talk about it hypothetically.
Right. So going into the pre-litigation example, this is an auto accident case. Let's just pretend it's a surviving spouse situation, and we'll leave the other scenarios for when we've got a probate attorney.
Right.
When it's a surviving spouse, the surviving spouse is the person who has signed the intake agreement. When it's time for the firm to receive the settlement check and get the settlement funds for the client dispersed, where does that check go? Who receives the settlement funds?
Yeah, it would be the surviving spouse that you've got the relationship with. Now they would have some obligation to disperse a portion of it to surviving children, but that is typically unless the firm represents all the children. I think that there's just a level of notice that the firm needs to make sure does go out. But if there's children that are estranged or that are not, or that actually have debts to the estate that can be set off. I think there's probably any number of. So in that sense, it would go to the surviving spouse if that's the only client that you've got, and but the surviving spouse would have to understand that if there are surviving children, that they may have claims that they'd have to consider satisfying.
I think that we have provided enough of questions,
Sure.
enough intrigue to get people interested, hopefully those people that are paying attention, to get interested into tuning in when we have a probate attorney. So this is the best sizzle reel. The entire episode is a sizzle reel. But do you think that there's anything that we haven't discussed in this prequel to the next episode?
So I think one of the things that we see typically is when a sudden accident occurs, that takes the life of a family member, it is so much easier to pursue claims on behalf of that family member, that if they have a will and they've already thought about who they want appointed as the administrator of the estate, and it's somebody that can be objective, not necessarily someone that is going to be as emotionally tied in. So if you have somebody outside of your family that you trust to be the administrator of your estate, not necessarily your attorney, but it can be an attorney, it can be a trustee, it can be somebody whose counsel that you valued, but someone that you believe can be entrusted with that fiduciary responsibility, to marshal all the assets and make sure that your will is executed in the way that you want. Then it's a lot easier to have that if that designation has already been made beforehand, to get the estate set up, because oftentimes a lot of what we're dealing with in getting to have a probate attorney set up an estate or to probate the estate of someone that died intestate is figuring out who amongst different available family members is going to be the administrator, and it often causes a lot of angst and brings up a lot of tough tensions amongst family members as to who's going to be appointed, who's going to be responsible.
We've experienced it on some cases we worked on together. Some of the family members don't realize exactly what that representation entails, so they think that it's worse, or that somehow they're going to get shut out.
Right. Exactly. And what they don't realize is statutorily their claims, their share in proceeds from a wrongful death claim are actually protected by statute.
Right. But because they may have a personal conflict with the person, they think that person is going to somehow prevent them from receiving their funds. If you've got problems in your family, you're going to want to tune in to the second part of this when we have a probate attorney, a state attorney, wills and trust attorney on the show. If you are in that field and you'd like to come onto the show, I welcome you. Reach out to us, send us a DM, leave a comment. As always, everyone else, especially Mom, share this episode, like the episode, subscribe.
Smash that subscribe button.
You're good
click that like button.
You're good at this. I don't need just Maddie and my daughters coming on here and teaching me how to get the YouTube engagement up.
Yeah, that's it. That's exactly who Ari and Maya. They don't have a YouTube channel. They've never posted anything on YouTube, but they know exactly how to end their videos when it says smash that like button.
Yeah.
And don't forget to subscribe.
As always, we take care of you. Please tune in. Until next time, take care, everybody.
Thanks so much.